Hello, my name's David Belbin. I'm Managing Partner of Clements Hall Cummings, and this is a webinar to just put in front of you some thoughts about Brexit. The UK is just weeks away from the end of the Brexit transition period on 31st of December 2020. After this, the UK will no longer be part of the arrangements that have made trade and travel to the continent so easy. At the time of this presentation, the UK is still to sign a new trade deal with the EU, and there remains a significant degree of uncertainty, which is making it harder for businesses and those who advise them to plan for the future. This has been made all the harder by the events of the pandemic, which continue to affect our everyday lives and the ability of many businesses to trade. It's clear that many businesses still aren't fully prepared for what lies ahead. But there are certain steps that all owners can take now to build resilience and ensure their business is ready. During this presentation, we hope to go over these steps and look at some of the implications that Brexit may have on your business, staff, suppliers, and customers. We hope to cover a lot of ground during this webinar, but our team are also standing by to answer any questions you may have in the weeks and months ahead. So, potential deal outcomes. Well, businesses remain uncertain exactly how trade will continue once the transition period ends on the 31st of December 2020. The UK government was said to be focusing on a Canada-style deal, but as negotiations became wrapped up in various issues, Prime Minister Boris Johnson warned the UK to prepare for an Australian-style deal. Now, if you're not an expert in international trade agreements, it may not be clear what the difference between the two deals means in reality, especially when it comes to the introduction of costly new tariffs. Canada has a trade agreement with the EU since 2017, known as the Comprehensive Economic and Trade Agreement, CETA, which gives Canada almost completely tariff-free trade in goods. The deal also protects EU geographical indications, whereby products with a specific geographical origin are protected, such as Camembert cheese or champagne. And this prohibits Canada from importing any goods using the same names from another country. So under CETA, Canada and the EU also cooperate on standards, ensuring that a product cleared under EU safety and security rules does not have to undergo further checks if imported into Canada. The main selling points of this deal are the increased quotas on exports, which allows a certain amount of product to be exported before tariffs are applied. However, it doesn't eliminate charges altogether. As an example, under CETA, the amount of tariff-free cheese that the EU can export to Canada increased from 18,500 tonnes to 31,972 tonnes per year. However, while 98% of products are tariff-free, import taxes do remain on some goods, such as meat, eggs, and poultry. Although these arrangements reduce regulatory trade barriers, Canada still faces more red tape and costs than EU countries do when trading with each other. Despite all the talk of an Australian-style deal, the reality is that Australia doesn't have a free trade agreement with the EU, although it's currently negotiating one. And should the UK trade with the EU using the current Australian terms, businesses would not have the favourable access to the EU market they currently enjoy. Instead, they would face the EU's Standard World Trade Organization, WTO tariffs, when exporting to the continent, and EU businesses would face the UK's standard WTO tariffs when exporting to the UK. This could mean that cars imported into the UK from the EU could be 10% more expensive, while the price of exported milk, cheese, and some meat would increase by up to 30%. More importantly, the UK's key services market would lose any preferential access to EU markets under an Australian-style deal. some commentators have pointed out, an Australian style deal is very similar to a no deal scenario. So let's think about our trade arrangements. From 1st of January 2021, the process for importing and exporting goods will change. Already there's speculation of long waits at borders and complications regarding the different types of licenses and customs declarations businesses need. And despite pledges to reduce red tape and bureaucracy, as things currently stand, businesses that import and export will need to undertake new steps under the new arrangements. Businesses must begin to prepare for these steps now so that they can continue to trade with minimal disruption. In its latest guidance, the government has laid out the principles for the core model, which relates to all goods imported and exported, regardless of which means of transport are used to move the goods. The guidance covers the core processes of customs declarations, customs duty, import VAT, safety and security declarations. And under each of these headings, it sets out the actions that businesses should take now, as they will be required to follow these rules regardless of the outcome of the ongoing trade negotiations. To help businesses adapt, HMRC will introduce new border controls in the core model in 3 stages up until 1st of July 2021. And to help prepare for these changes, businesses should apply for an EORI number. Prepare to pay or account for VAT on imported goods. Consider commercial arrangements and terms of trade. Determine the customs value of goods. And businesses should be considering how customs declarations to the HMRC systems will be made and the use of a customs intermediary. Businesses in certain industries may also need to check what export licenses or certificates they require, the marking, labelling and marketing standards for food, plant seeds and manufactured goods, the rules for exporting or importing alcohol, tobacco and certain oils. And to help with this process, the government has produced a step-by-step checklist for importers and exporters, which can be found on the gov.uk website. Now, if you do move goods into Northern Ireland or via it into the EU, you should also sign up for the government's free traders support service. This free-to-use service is available to businesses of any size moving goods into Northern Ireland, providing guidance, training, a digital declaration support service, and support from customs experts. So, think about VAT now. VAT is complex at the best of times, but the Brexit transaction latest guidance makes the process of accounting for VAT on imports and services to and from the EU even more difficult. For import VAT, goods that move into the UK from the EU after 1st of January 2021 will be considered imports, meaning import VAT and customs duties will be payable and customs declarations will need to be made. Import VAT will no longer be payable when goods enter into the UK from 1st of January 2021, and businesses will instead account for VAT on all goods imported using a postponed accounting system. This means that import VAT will be accounted for and paid via the usual VAT return, which for some will lead to an improved cash flow position. This applies to all goods imported by VAT-registered importers to the UK, including those from the EU. In most cases, import VAT should be recoverable by businesses, but duty costs are irrecoverable. Now, how do you account for import VAT on your VAT return? Businesses will have to account for import VAT via their VAT return under the postponed accounting system if the goods they import are for use in their business. The business must include its EORI number, starting with GB on its customs declaration, and their VAT registration number if it is needed. A business can then account for import VAT on its VAT return when they submit the declaration that releases those goods into free circulation from one of the following special customs procedures: customs warehousing, inward processing, temporary admission, end use, outward processing, and duty suspension. The business can only account for import VAT on their VAT return once they release excise goods for use in the UK, also known as released for home consumption. If the business imports goods that are not controlled into Great Britain from the EU between 1st of January and 30th of June 2021, they must also account for import VAT on their VAT return, even if they delay the customs declaration or use a simplified customs declaration to make a declaration in their records. Deferring duty. New rules for duty deferment will apply in Great Britain from 1st of January 2021. These will allow businesses that import goods regularly to apply for a duty deferment account to delay paying most customs charges, including customs duty, excise duty, and import VAT. Through this account, a business can make a single payment each month via direct debit instead of paying for each individual consignment separately. The scheme is open to importers or customs agents and freight handlers that work for importers and have an approved deferment guarantee or waiver in place. Regardless of the method of accounting for VAT on imported goods, checks to ensure that the data on customs declarations is accurate will continue to be highly important for VAT purposes for all imports. This will be the primary means to ensure that the correct import VAT is accounted for and paid. Now, for consignments of value below £135, imported goods in a consignment not exceeding a value of £135, excluding specific excise goods and gifts, will not be subject to import VAT at the border. Low value consignment relief will be withdrawn and VAT will be charged on the goods as if they were supplied in the UK and accounted to HM Revenue and Customs on the UK VAT return. However, businesses selling goods to be imported into the UK with a value not exceeding £135 will be required to charge and collect any VAT due at the time of sale. For UK VAT registered businesses importing goods in a consignment not exceeding £135 in value that has not been charged VAT at the time of purchase, they can account for this VAT on their VAT return under the usual reverse charge method. Businesses must determine the country where a supply takes place for VAT purposes so that they know where VAT due is payable. At the moment, the place of supply rules are applied almost identically across the EU member states, and it is expected that the UK will retain similar rights after the transition period ends to prevent disruption. However, a consequence of this is that businesses may continue to create VAT liabilities in other EU member states. This may mean that businesses in the UK will require multiple EU VAT registrations within each member state that they trade within. Further clarity on this is expected in future government guidance and may be affected by the outcome of the ongoing trade deal negotiations. So, currently, UK firms incurring VAT in EU countries can claim VAT back, subject to national rules, via the HM Revenue and Customs dedicated refund portal. That arrangement will remain in place until 31st of March 2021, after which time there is currently no provision in place to claim for VAT incurred in the EU under terms of the withdrawal agreement. Post-Brexit, there should be minimal impact on the supply of services. Business-to-business services are generally treated as though they are supplied where the customer belongs and that customer must account for the local VAT. So this means that for UK service suppliers, they will continue to not charge UK VAT For business to consumer suppliers, UK VAT generally applies, and this is likely to remain unchanged. When receiving services, it is expected that UK businesses will still have to apply a reverse charge to the receipt of services from non-UK suppliers. And this would ensure that there is no competitive advantage from sourcing services via non-UK suppliers. So let's think about people. The end of the transition period also signifies the end of the free movement agreement between the EU and UK. This may mean that steps need to be taken to retain existing talent or recruit new talent where the employee is a EU citizen. Employers should check whether existing employees from EU member states need to apply to the EU settlement scheme. A person is eligible for settled status if they started living in the UK by 31st of December 2020 and have lived in the UK for a continuous 5-year period. 5 years continuous residence means that for 5 years in a row they've been in the UK, the Channel Islands or the Isle of Man for at least 6 months in any 12-month period. If they do not have 5 years continuous residence when they apply, they'll usually get pre-settled status. To get this, they must have started living in the UK by 31st December 2020 and can stay in the UK for a further 5 years. They can then apply to change to settled status once they have 5 years continuous residence. Some EU citizens may be able to stay in the UK without applying, for example, Irish citizens or those with indefinite leave to remain status. The deadline for applying for settled status is 30th of June 2021, so it is important that this process is completed before then, and businesses wishing to retain talented EU citizens may wish to help employees to prepare the necessary application. After the transition period, you can still recruit EU citizens, but you will need to apply for permission and the correct visas. In order to recruit workers from outside of the UK in the skilled worker category, you will need to demonstrate that they speak English at the required level, they have a job offer from a Home Office licensed sponsor, the job offer is at the required skill level, RQF3 or above, equivalent to A-level, and that they will be paid at least £25,600, or the going rate for the job offer, whichever is higher. If the job pays less than £25,600, but more than £20,480, the applicant may still be able to apply for permission by trading points on specific characteristics against their salary. For example, if the worker has a qualification in a relevant job or has a job offer in a shortage occupation, there are also different salary rules for workers in health or education jobs and new entrants who are starting their careers. The new system will not apply to EEA or Swiss citizens already employed in the UK, as they can use the EU settlement scheme. To become a Home Office licensed sponsor, you must apply online and do the following. Firstly, check that your business is eligible. Choose the type of license you wish to apply for, which will depend on what type of work you want to sponsor. Decide who will manage the sponsorship within the business and pay a fee. You will be given a license rating and be able to issue certificates of sponsorship if you have jobs that are suitable for sponsorship. And this will remain valid for 4 years, as long as you check that your foreign workers have necessary skills, qualifications, or professional accreditations to do their job, and keep copies of documents showing this. But you only assign certificates of sponsorship to workers when the job is suitable for sponsorship, and that you tell UK Visas and Immigration, UKVI, if your sponsored workers are not complying with the conditions of their visa. The rules are not straightforward, and it is therefore advised that you seek professional advice. Think about overseas business travel. From the 1st of January 2021, there will be new rules to travel to the EU, Switzerland, Norway, Iceland, or Liechtenstein. Should you or any representatives of your business need to travel to the EU in future, you may need to consider the following. Check your passport. Get travel insurance that covers your healthcare. Check that you have the right driving documents. Tell HMRC that you'll be working in the EU. Check whether you'll need to pay social security contributions in the country you're working in. Check whether you need indemnity insurance for your employees while they're there. And check you've got the right documentation to take goods to the EU. It is important you conduct a review of your entire organisation to assess the impact of employee travel post-Brexit and how it may impact on your ability to operate and grow your business. So, it's easy to get lost in the doom and gloom that is being reported around Brexit at the moment, but the new freedoms gained from the UK's departure from the EU could also open up new opportunities and markets. Already the UK has signed a comprehensive free trade deal with Japan and is in discussions to create a larger agreement with Canada, Australia and New Zealand, the so-called CANS UK deal. Discussions are also ongoing with the United States regarding a trade deal, but the recent election of Joe Biden has raised a few questions about the speed at which negotiations can be completed. More generally, the departure from the EU should allow the UK to establish new trade deals with a wide range of markets. However, EU remaining the country's largest trading partner, achieving a deal with the bloc remains a key goal. So, as we bring this to conclusion, as the UK is yet to secure a deal, businesses must consider the following. Think about implications for VAT on your business. Think about the introduction of tariffs, the effect it will have. Make sure you're conversant with the new requirements for importing and exporting goods, that you're aware of the new border controls, that you understand the needs of EU citizens in your workforce. Think about the impact of all of this on your supply chains and do some scenario planning just in case things change. You should take time to review all of these points and consider the direct and indirect impacts on your business so you can put plans in place to mitigate any issues. So how can we help? Well, UK businesses face an uncertain period full of variables that could affect their income and ability to trade. When there are new announcements, then please do go to our website because we're putting information up regularly about this fast changing area. We're supporting a number of businesses with their preparations for Brexit and we're standing by to support you should you have any queries or require any form of support. If you'd like to know more about the impact Brexit may have on your business, how we can help, why not arrange a consultation with one of my colleagues or myself to find out how we can assist you. Thank you.